Good morning, everyone, and welcome. My name is Ian Quayle from IQ Legal Training, and I'm delighted to be invited by Geodesys to do a presentation on commercial property. And I'm over the moon that I've got Toon from Geodesys with me today. Kay, it is lovely to see you. We were supposed to be in Colchester Zoo, but I am now still up north. And I'm pleased to say it's not quite as cold as normal, but it's certainly not sunny. We've got a bit of rain this morning, but apart from that, life is good. Kate, thank you so much for coming along today and inviting me along today, and for Geodesys, I always get it wrong, don't I?
Got it right this time.
For sponsoring this event. It's lovely that organizations that have a brilliant service and a brilliant product can also support the legal profession in providing CPD events such as this, and allowing me to have my two penneth for a couple of hours, telling people my very limited knowledge and my experience in connection with conveyancing matters, commercial property matters, etc. So thank you, Kay, for inviting me along. Kay, before I sort of do my sort of CPD bit, as it were, if you could explain to practitioners a little bit about what you are and what you do, I think that would be really useful. So I'm happy to sort of manage the slides that are on deck. And if I hand over to you for a minute, will that be all right?
Yeah, of course, no problem at all. Thanks, Ian. First of all, thanks everybody for coming to this commercial forum webinar. I hope you find it interesting. For those of you who've not worked with Ian before, who don't know Ian, Ian likes it interactive, so please feel free to put as many questions or anything in the chat box that you need to. Now, today I'm just going to briefly talk to you about all the commercial reports which are out there, and just to get you thinking about, are you ordering the right one? Now you have the two main searches which you're all familiar with, which is the official local authority and the commercial Con29DW. Here at Geodesys, we actually produce the commercial Con29DW on behalf of Anglian Water. And then you have all the environmental searches, Ian, please. There's an absolute plethora of environmental searches on the market for conveyancers to choose from. And I always say, looking through environmental reports for commercial is like looking through a wine list. People are always doing the same thing. They're either going for the cheapest or the medium one, but never really trying anything different. Next slide, please, Ian. So although on the surface, many searches can look and sound the same, environmental searches in particularly can differ. So what should you be looking for? It's not all about the price. A lot of environmental searches may seem more expensive on the surface, but it's definitely worth looking at the detail behind the price. Combined Risks offers a more comprehensive analysis of the actual multiple risks in one report, and are thorough in their initial assessment. So what that means for you is there's less confusion about the results, and there's actually less delays and a further reduction on actions, because you're not going to and fro to your clients asking and answering questions, because they're all in one report. Now, as you are aware, the Law Society is making so many changes and so many guidance to different practice notes all the time. And with that in mind, reports are changing as well. So I would say it's worth definitely reviewing on an annual, biannual basis what you and your team are purchasing for environmental reports, just to give you the confidence that your teams all are ordering the correct one. Next slide, please, Ian. Now, the searchers form 3 forms of assessment, and not all of these are equal. So you've got the first one, which is automated. So this is where you type in your address boundary, tick your environmental search, and it would normally be back with you in around about 1 to 2 hours. And that's because it's completely automated. You then get the semi-automated ones. And basically that's the same as the first one, except with this one, a consultant will look over it and assess if there's any risks. So they may say, oh, you need an additional flood report, contaminated land report, something like that. And then lastly, you get a consultant assessment. And this is where a consultant will look over the address, fully compile and write the assessment, plus leave any contact details. And the contact details are for you or your client to give them a call anytime with any questions. So that helps you as well. Next slide, please, Ian. So I would also say, as well as the usual local authority, commercial, con and environmental searches, the other 2 reports I would always say you should consider for commercial is definitely highway solutions. Now, with this report, as well as providing adoption status of the roads and footpaths, etc., of the surrounding area, for me, section 2 of this report is really important because it provides traffic alerts. It will tell you what roadworks are planned around the site for the next 6 months. It will also give you details of which utility report is responsible for those delays and the severity of them. So let's say, for example, if your client's going to open a restaurant with a particular launch date in mind, if that road is going to be closed, then your client could think, well, do I want that particular site or not? And in addition to that, it's important to consider what impact proposed changes to things like on-street parking, waiting and load improvements, and any other road improvement schemes could have on businesses around the area. The other report is a utilities report. And for a utilities report, I would say, why would you need it? For any redevelopment, knowledge of features below the surface is essential for every development. And the benefits of this knowledge, obviously, is ensuring due diligence for your client and avoiding risk, but also being ascertained the feasibility of the development itself. So next slide, please, Ian. Going back to my original slide, when you look at environmental searches, you need to have one main question in mind. And that main question should be, is what commercial transaction type is it? Mouse in, please. Because if your client is purchasing a newsagent and it's going to remain a newsagent, then that's like for like. If your client is purchasing a newsagent and they're going to change it to a hair salon, that's change of use. So just to get you thinking, I hope your search pack doesn't look the same for both those different commercial transaction types. And the last slide, please, Ian. So we are more than happy to help you with this. We can run totally free of charge a which reports CPD session with you and your team to look at the different commercial type scenarios as to what best report suits that commercial transaction type. And I'm happy to deliver this face-to-face or via webinar. If it's face-to-face, I'm happy to provide lunch or cakes if it's in the morning. So please feel free to contact me. So that's it from me. Now back over to you, Ian. Thank you.
Kay. Thank you very much indeed. A number of points really before I start my presentation. Firstly, one of the things that Kay said there sort of resonates with me, this idea about making sure in a commercial transaction, you know your client's objective. You know, what is the purpose behind this transaction? And on a purchase, it's imperative that we ascertain what our client intends to do with regard to the property, and that we tailor our due diligence to that target and to that objective. One of the things with the use of AI, the use of sort of systems, case management systems, etc., all of which are brilliant, means that a lot of the sort of procedural issues, some would argue the drudgery of the conveyancing process, is taken away from us, which means that we've got more time to sort of focus in on what the client wants and what the client needs. So made that the fact that there isn't just one standard type of environmental search, we should be thinking about client objective and looking to tailor the data and information that we're producing for the client becomes so important. So I agree entirely with Kay that you shouldn't just say, right, there's a standard report that we trot out in connection with every transaction. Let's have a look and a think. And I think the other thing, Kay, that I would always say to clients is, you know, here's a choice. You know, that here's the spectrum of stuff that we can get for you. What would you like? And I'll have some clients that will always say, I want the cheapest. I'll have others that are risk averse, or there might be a transaction where there's a particular issue in mind where they'll say, no, thanks very much, I need that one. So you were saying about utilities. There was a case last year, I don't know if you saw it, a case called Spire against Withers that ended up in the Court of Appeal, where there was some electrical cabling going underneath a development site. And standard searches wouldn't have picked that up, but a utility search would have done, and it might have warranted further investigation by the client or the lawyer or a surveyor. So always think about client objective, always think about providing added value. And as I say, there's no such thing as usual searches. There's no such thing as standard due diligence anymore. In a commercial transaction, you've got to be able to pivot and move depending on what the client wants. Something Kay didn't mention, which again, I think is so important. When you're dealing with companies that are providing services and product, it's essential that the people that you're dealing with are nice to deal with. They're expert in their field and they can help and what I class as handhold. And I know that Kay and her colleagues are excellent at doing that. So it's not just a company. These are individuals working with a company who are nice people to do business with, supportive of you and your aims in connection with due diligence relating to acquisition, and a sort of part of the team. But I think that's so important to you, Kay, that you know you're not just providing a service, and you're not just providing cakes and lunch. You're there to support fee earners, and depending on the transaction and depending on the fee earner, there's different levels of support. Yeah, Kay, you're going to say something?
Yeah, I mean, I totally agree. We consider ourselves partners, and like you say, a part of the team. That's very important. So if secretaries or fee earners have large difficult plots, a lot of portfolio work, some people charge to do things like that. We don't. We consider it as all as part of a service. So I have many emails come in every day saying, Kay, can you plot me this? Or I've got these 20 properties that I need searches for, and I'll just do it as part of the course because that's our day-to-day business. Yeah.
Thank you very much, Kay. Kay, that was really enlightening. So thank you for that. Kay's going to remain with us. So if you have any questions or queries, we can contact Kay at the end of the presentation. There's her contact details. Do take a picture of that slide and speak to Kay and speak to her colleagues. Often, again, you know, you may be a customer, an existing customer, but just having a look at the website and just seeing what this company and this organization is up to is always worth a quick scan on the website. There may be new product, there may be new ideas, etc. And again, you know, 2 or 3 minutes just having a look at the website or talking to Kay can be very valuable. Anyway, Kay, thank you for that. Now for
thank you, Ian.
Now
I will switch my video off.
Absolutely, now. That's all right. Have a cup of tea and switch it off. That's fine by me.
Thank
Now for
you.
the boring bit, me. What we're going to do now is we're going to talk about some issues relating to commercial property and a sort of an update. And what I'd like to do, I think, is to look at some issues with regard to scoping the retainer, to look at some issues with regard to due diligence. We're going to have a deep dive into some issues with regard to restrictive covenants. I'm going to share with you some thoughts with regards to climate change and the new Law Society guidance. And because I spend 50–60% of my life at the moment dealing with Building Safety Act issues, I thought we'll have a scamper through some Building Safety Act issues for commercial property lawyers. So hopefully you're sitting comfortably, hopefully you can see the slides, and hopefully you can see me. If you have any questions or queries, I will allocate some time before we finish the presentation to deal with those questions and queries. I'll also provide you with my contact details. You're more than welcome to drop me a note via email with any questions or queries that you may have. So first things first then, I want to talk about the retainer. Then I want to talk a little bit about what due diligence actually involves. And as I say, this principle of not just providing information, but providing explanation and advice as well. To look at client inspection, because I think that's so important in the commercial property context. And of course, to talk a little bit about searches, focusing in on climate change issues. Before I do that, some useful websites for you. If you're doing commercial leasehold, commercial landlord and tenant work, all of these sites are very useful. The PLA site is now a subscription service, but I'm sure if you have a property litigation team, they will already subscribe to it. Useful case law update section, useful sections on business lease renewal and all manner of different things. City of London Law Society will highlight or flag up developments in the law, changes, and comes up with practice ideas, and also is a useful resource for precedents, rent deposit deeds, model forms of reports on title, clauses for commercial leases, all sorts of things there that are really useful for you. Property Protocols is a commercial property site devising a series of protocols that are relevant to commercial property lawyers. And this last site, modelcommerciallease.co.uk, is a useful resource for precedents for commercial leases. Just thought I'd mention those as a sort of useful resources for you. Most of them are free, other than the PLA website, which I mentioned. So let's have a look at scoping the retainer in commercial transactions. And guess what the first point I make is today? Imperative that we identify client objective in connection with every transaction. We might be acting for a residential developer who's frequently buying residential sites, but surprise, surprise, the instructions that we get this morning, he's buying a site or she's buying a site for some other purpose. It might be that they've decided rather than building residential property due to the state of the economy, mortgage market, etc., they've got a site that they had planned for resi development and they're now thinking about an alternative. So we need to know that. We can, if we're doing a lot of work for a client, have a protocol with that client that states that unless the client tells us to the contrary, the assumption is that the transaction will be a standard transaction. Acquisition of a leasehold property for retail purposes, acquisition of a residential site, whatever it is. If not, then there should be an engagement letter, a retainer letter, and in that retainer or engagement letter, we should be specifying client objective. Where the client doesn't have an objective, that should be made clear. It is important that we scope our retainer at the outset, and in doing that, we're going to highlight to the client the work we're going to do. We're going to highlight the limitations relating to that work. And I think it's important now that we highlight the work that won't be done. So in highlighting the work that we're going to do, it's important that we explain the roles of third parties, surveyors and valuers, search providers, etc. It's important that clients understand and appreciate that we will not be inspecting the property. Therefore, we're dependent on client inspection, survey, valuation, and/or disclosure from the seller. It's important that clients understand the conveyancing process, if appropriate, with a sophisticated commercial client that's forever wheeling and dealing in whatever they're wheeling and dealing in, unnecessary to repeat what the process actually involves. Well, let's assume we've got a first-time buyer who's buying a hairdressing salon, a freehold to a salon and the business itself. It's important to explain to the client the process. If we have a client that has historically acquired freehold sites, but now is acquiring a leasehold development, again, it's important to explain the radical difference between the two. So with the sophisticated commercial clients, no need to explain process or documentation. With unsophisticated clients, clients that are new to a particular area, it is necessary. I remember years ago acting on behalf of a client of ours that basically was a company that was involved in laying pipelines in the North Sea. So it was sort of in the offshore industry, and we were buying depots for them. And we must have bought 4 or 5 depots up and down the East Coast, including Scotland. And they then decided that they wanted to go into the leisure industry. And they bought a business that was a hotel and sort of leisure complex in Aberdeen, I think it was. It was somewhere bizarre. In those circumstances, you know, the client was going completely off-piste with regard to that acquisition. Our Scottish lawyers that were acting for the client in that particular case had to be very careful to explain to the client the radical difference between freehold and leasehold ownership. So again, important to highlight that the client understands process, documentation, and our role. I mentioned the penultimate point on slide here, highlighting the limitations of the work to be done. We're not going to advise the client on the commerciality of the transaction. We're not, in most circumstances, going to be inspecting the property. As far as due diligence is concerned, you know, searches, local land charges searches are property specific and don't carry any form of priority. Important that clients understand that if, for example, a local land charge is missed from a local land charges search, an official search, it will be binding on our client, but nonetheless, our client will be entitled to compensation. One of the things that Kay mentioned, which I think is so important, are issues associated with highways and the fact that we will be able to obtain information relating to highways from the Highway Authority. But the Highways Authority's records aren't necessarily complete and aren't necessarily accurate. I do a lot of work for my sins. So do a lot of training for the Institute of Highway Engineers, and it's often amazing how poor the maps and plans that highways authorities have. And therefore, you know, if you're buying land adjacent to the highway, you can encounter all manner of difficulty with regard to lack of clarity. Again, it's important that clients are aware of that fact. In highlighting what we're not going to do, we need to be careful, because there is a sort of an overarching principle, which I mentioned in the notes, about the duty of care that we owe clients. So anything that we become aware of that would be materially adverse to the client's purchase, we should draw to the client's attention, even though that's beyond the scope of our retainer. So in a residential transaction, the duty that we owe the client is far greater than in a commercial transaction. In a commercial transaction, the courts will accept that we can apportion risk in connection with the retainer. So we can tell clients that we won't be advising on environmental issues or planning issues or issues relating to climate change, etc. We can do that. And if the client is happy to proceed on that basis, then fine. In a residential transaction, the position is slightly different. And as I say, with regard to climate change, as a result of the Law Society guidance in April, the position is different too. So some basic issues. The retainer should be in writing. It can limit liability. It should provide information. It should provide explanation. As far as advice is concerned, advice is of a general nature may well be contained in our engagement letter or in our retainer. It may then be supported in our report on title. The important point to extract here is that the retainer and the report on title need to be consistent with one another. The job really of a conveyancer in any aspect of conveyancing work when acting for a buyer, in my view, is to highlight risk. And in commercial transactions, that's even more important. And of course, as Kay was alluding to, the risk with regard to environmental issues is that we're acquiring a site where there is pre-existing contamination that ultimately is going to fall on us in connection with responsibility for cleanup or decontamination. Suppose also there is risk with regard to contamination migrating on site, and where we're a freeholder that's building industrial units or retail units, there's a risk that our leaseholders, our tenants, might contaminate the site and generate risk for us too. So it's important that what our job is to highlight risk. As far as assessing or determining the extent of that risk, in the vast majority of issues with regard to a commercial property transaction and indeed a residential transaction, it's not our job to assess or determine risk. The only exception I would say to that is risk with regard to title. So it is necessary if we're buying a leasehold and it's a good leasehold, or we're buying a freehold site that we think is freehold and there's a possessory or some form of qualified title, it's important that we tell the client about it and that we highlight to the client the issues that that problem potentially generates. Now, I have to say, in the past, I've asked for clients, and there's been an issue with regard to a possessory title or a good leasehold title, and the client hasn't cared less, on the basis that all he wanted was an industrial shed or a facility for his business, and the quality of title that was offered to him was irrelevant. But again, it's important to explain the problem on the basis that at some point it might be necessary to sell the site, or it might be necessary to sell the business, including the site, and a buyer's solicitor or conveyancer might raise an issue with regard to the quality of title. Further, if our client is going to be using land or property for financing purposes or security for finance, then again, that could be issues or could generate issues. So let's talk about due diligence in commercial transactions and commercial inquiries before contract. Of course, the seller will produce these. The seller will perhaps include a disclaimer in the replies to commercial inquiries, may well limit liability in connection with the contract and special conditions, and could specify who has produced the replies to commercial inquiries and highlight their lack of knowledge or lack of awareness, thus reducing the risk of the statements in the replies to commercial inquiries inducing a buyer. Do be aware that the commercial inquiry is altered as of the end of May to deal with issues associated with the Building Safety Act. More on that before we finish. And do be aware from a buyer's perspective that it's all well and good to tell a buyer client if the seller lies or makes an error with regard to replies to commercial inquiries before contract, then the buyer can sue the seller for misrepresentation. I would always warn a client, although it's possible to bring an action for misrepresentation, your client buyer may not have an appetite to do so when he finds out the potential costs that would need to be incurred in that connection, the risk associated with being liable for the other side's costs where the proceedings are unsuccessful, and of course the economics of litigation, a seller that's unable to pay damages or a seller that disappears into the ether, having unsuccessfully defended proceedings. I always say to buyer clients, no matter what the context, the commercial inquiry should be used as a checklist for the buyer client to check issues during the conveyancing process and to report to me anything that's revealed as a consequence of the examination of that checklist. It's not unfair to raise additional inquiries in a commercial transaction. As far as those additional inquiries are concerned, again, they need to be targeted. And again, where responses are provided, a buyer client needs to be warned that although it may be possible to bring an action for misrepresentation, such an action may not actually be successful, economically successful. Before I leave the issue of commercial inquiries before contract, one other point. There was a case just decided this year where an agent had provided to a buyer who was buying a buy-to-let investment property plans and drawings showing this was a two-bedroom flat or apartment. And the seller was advised in the TA forms, in the residential forms had been used rather than commercial forms, that the seller was not aware that there was been a breach of planning or a breach of building regs. In fact, the flat or the apartment had a second bedroom with a Velux window, and the Velux window had not had planning permission and was in breach of building regs, which meant that the second bedroom, in essence, had a Velux window which had to be taken out and the roof replaced or restored, meaning that you had a second bedroom without any natural ventilation or light, meaning that it couldn't be used for occupation. The buyer sued the seller, and the seller was held to be liable in misrepresentation. One, for the information which its agent had provided to the buyer, and two, because the seller had not checked, in fact, the position with regard to building regulations and planning. In other words, the seller had assumed there weren't any issues without carrying out reasonable checks or inquiries, and the court held as a consequence they were liable for misrepresentation. If anyone wants details of that case, ping me an email before we finish, and I'll send you a copy of the case report. As far as searches are concerned, important, as really what Kay was saying, there's no such thing as usual searches. There are essential searches. There are searches that are potentially necessary given locality, given transaction, and given client objective. And then there are searches that are available. And I think what we do with regard to searches is we say to clients, look, these are the searches we must do. Given the transaction, given the location, given the objective, these are the searches that you ought to do. But by the way, here are some other searches that might be necessary, might be appropriate in connection with your acquisition. Now, when I mention this to practitioners, I sometimes get a pushback. Ian, I don't want to tell clients about all the searches that are available on the basis that clients will start asking too many questions about them. So I suggest what you do is you highlight searches that you think may be appropriate given client objective, but then say to client, look, there are a list of other searches that we are able to obtain for you, depending on whether or not you want them. I think that's service. I think that's important. And I think particularly with commercial clients, you know, the client might have a particular niggle or a particular concern about a site. And the fact that we can obtain a search or information relating to the issue that's causing that niggle or causing that concern is useful. What does case law reveal? Case law reveals that where we are obtaining searches, we must advise the client of the search result. Where the search reveals risk, we should highlight to the client what that risk is. We should then highlight to the client the possibility of investigation relating to that risk. That investigation could be carried out by us, could be carried out by a third party, could be carried out by the client themselves. Where the client requires us to undertake further investigation, given what I said earlier, I think it's potentially important to extend the scope of our retainer to make sure the client is aware of what we're now going to do. So we're going to engage a member of our planning team or a member of our construction team to provide advice with regard to an issue or a problem. Or we're going to submit a report to a surveyor or a valuer with regard to an issue that the search reveals. There's a number of cases where clients were not informed about search results, and that's sort of a fundamental error, isn't it? So where you get a search in, tell the client about it. It isn't enough just to give the client a copy of the search, but highlight issues relating to risk that the search reveals. I mentioned on slide SIM searches, and a SIM search, which you may connect to a search of unregistered land, I think is important in a number of different commercial contexts. Firstly, where we're doing a site assembly project. So we're acquiring 3 or 4 parcels of registered land, or a parcel of registered land and a parcel of unregistered land. If those parcels apparently abut one another, it's important to do a SIM search to check that is the case. I couldn't tell you the numbers of times I've done site assembly projects and we've bought registered land in, and we think that the sites abut one another, and then when you look at the title plans, in fact, they don't. There are slivers of unregistered land sitting between them. And in those circumstances, you'd think the obvious thing to do is to ask the land registry to simply incorporate those slivers of unregistered land into the registered titles, given that we own the land all around. But frequently, land registry officers will refuse to do that and will instead suggest that what we do is wait 12 years and bring a claim for adverse possession relating to those slivers of what is or are unregistered land. So SIM search useful for that purpose. As site assembly, boundary sensitivity issues, do a search a meter beyond the site to see what the position is with regard to a neighbour's title or the extent of unregistered land adjoining. A SIM search might also be useful where we're buying a building that's subject to multi-occupational tenancies. So we might have a series of leases, have those leases been registered at the land registry. Sometimes the landlord is not in fact aware that the lease has or hasn't been registered when it should have done. So often, as I say, where we're buying an industrial estate, where we're buying a shopping centre or a building that's subject to multiple occupancies, a SIM search of that building will provide us with a picture that will be useful. I mentioned local land charges, and again, a local land charges search is important. Local land charges are overriding interests. They are binding on our buyer client, whether they're revealed in a local land charges search or not. And therefore they are important, particularly financial charges that could have a bearing potentially on the buyer in connection with the buyer becoming liable for outstanding financial charges. The other point with regard to a local land charges search is that it doesn't carry any form of priority, obviously, and it's also property specific. So it might be necessary, and Kay was touching on this, to sort of extend the scope of search or searches in connection with adjoining land or nearby land that could have an impact on our site or on our intentions relating to the site that's being acquired. Other searches, well, utility searches, Kay mentioned, environmental searches, essential in my view. On the issue of environmental searches, 1 or 2 points to note. Firstly, and again, Kay touched on this, I'm delighted to say, an environmental search and report, I think, is necessary. An environmental search might just give us historical land use or current land use. A report will give us a risk assessment. If there is contamination, what risk is our client exposed to? That's the first point. Second point, I would advise a client who is acquiring a leasehold interest in a property to undertake an environmental search. And I'm going to be really confrontational here and suggest even where a client is taking a relatively short-term commercial lease, an environmental search might be appropriate. Why would I say that? Well, one, if a tenant acquires a leasehold interest in land, and that land is contaminated, as an occupant of the land, the leaseholder, the tenant, could be liable for decontamination, could be liable for the obligation to decontaminate or costs associated. How? Well, let's assume the original contaminator is long gone. Let's assume that the landlord is a landlord that's in liquidation or administration and therefore is not going to have sufficiently larger checkbook to pay for decontamination or cost incurred by the Environment Agency. And let's assume that our tenant is a sort of a blue chip tenant with a very healthy bank balance. It may well be that the tenant becomes the obvious source of redress. In addition, of course, in most commercial leases, there will be provision that enables the landlord to transmit into service charge costs incurred in connection with the service or receipt of statutory notices relevant to the property. In a lot of commercial leases that I've seen, nuisance covenants have the potential to bite tenants on the basis that contamination could be regarded as a nuisance, and where a landlord is liable to remedy nuisance, the cost of that remediation could well be capable of being transmitted into service charge, thus leaseholders being liable to pay it. I mentioned inquiries of local authority, important. I would always advocate that inquiries are made of local authority, and additional inquiries I think are prudent, and I would certainly advise any commercial client as to their availability and what they're likely to reveal. There was a site a few years ago where inquiries of local authority would reveal issues associated with development on land adjoining or adjacent to site. But what you had was the building of a park and ride scheme that wasn't adjacent or adjoining, but was nearby to the site, that would cause sort of traffic disruption and would cause noise at various times, day or night. So the client that was buying a site for a factory where noise emission was important and silence useful, so it was an issue with regard to some highly technical sort of audio equipment that was being produced. Noise, particularly noise and disruption in the night and in the evening, where some of this sensitive work was to be undertaken, would be very disruptive indeed. So additional inquiries of local authority would have revealed that activity, which would have had an impact on the client's decision to proceed with the site acquisition. The site was acquired and then quickly disposed of on the basis that the problem was identified. Fortunately for the client, it was able to sell the site, get out of the site at a profit rather than loss. This point about generating added value is important, and really is the point that I was making when we're talking to Kay a little earlier. The idea that we're a team and that our search provider should be part of that team. So frequently, explaining to clients the additional searches that can be undertaken, the benefits of searches that can be undertaken can be really useful. It might be that sort of getting a picture early on with regard to a site could save a lot of time, energy, and stress from the client's behalf. And certainly linking client objective to our due diligence, personalizing the work that we're doing, is going to certainly generate added value. And I think it's so important now from a client's perspective to be giving added value, to not just be simply being a sort of processional lawyer that goes through standard hoops. Doing different things, focusing in on client need, I think is so important. Remember what the SRA and Law Society have said over recent years, this idea about getting to know your client, making sure that you understand what the client's expectations are in connection with the client's relationship with you with regard to this transaction is so critical. I think the provision of searches, the reporting of search results, personalization of what we're doing with regard to service is so important. I speak on a regular basis with professional indemnity insurers and insurance brokers. And this is one of the things that they sort of say to me, that the amount of claims relating to procedural errors are in decline, but the amount of claims relating to communication or a failure to consider client objective and targeting due diligence to that objective are on the rise. So just be aware of that, please. And I want to talk about climate change, and climate change in the context of commercial property lawyers. And the first thing to state is that the Law Society produced guidance on the 19th of April 2023. Nothing out of the blue with regard to that, given that Stephen Troman KC of Essex Chambers had produced a paper last year, an opinion last year on climate change. Some thought that Stephen was saying that you are negligent if you fail to obtain a climate change report on your client's behalf. I don't think when you drill down, that's what Stephen is saying. I think what in essence he's saying is that you should advise clients about the availability of a climate change report, which is slightly different. There was, a few years ago, something called the Chancery Lane Project that generated a series of what were called Marnie clauses. These are clauses that could be incorporated into the retainer or report on title by conveyancers or solicitors, highlighting climate change issues. Again, quite interesting. And if you Google the Chancery Lane Project, you will see the project itself and the Marnie clauses which you can utilize. Stephen Troman KC's opinion is also generally available to you to have a look at. There are now climate change reports that are sort of specific reports on climate change. There are other environmental reports that will include climate change issues. Remember what we said about information, explanation, and advice. Well, how does this relate to searches? Well, we've already spoken about essential, necessary, and available searches. How does this relate to a climate change report, for example? I think it's necessary to tell our clients that we can obtain the report. I think it's important that we explain to clients in very general terms risk associated with climate change. We cannot give advice about climate change. The Law Society guidance suggests that we all get sort of training on climate change so that we can give advice. The Law Society's guidance in April was generic advice for all practitioners. I'm told that there will be specialist advice for property lawyers to come at some point in the future. My stance at the moment is not to give anything that would be regarded as advice relating to climate change, to limit your retainer so the client is perfectly aware that that will not be the case. I think what you do, however, courtesy of the Law Society guidance, is highlight to the client about general risk. So, can we ignore climate change in connection with due diligence? Answer, I don't think we can. Should we insist that a client obtains a climate change report? I don't think we can do that either. Should we recommend it? I think yes. And the reason I think yes is because we've now got guidance relating to it from our professional body. And in addition to that, climate change is an issue. In some way, shape or form, the planet is changing, climate is changing, and that will impact on property ownership. Can we advise on content of a climate change report? I think you're very brave if you do that. And I have yet to meet a property lawyer that was sufficiently qualified to be able to give advice on content. And when you start looking at content, what exactly do you advise on? Because I wouldn't for the life of me suggest that looking at what climate change is going to do to a property in 10 or 20 or 50 years' time is speculation. I think it is certainly beyond speculation, or significantly less than speculation, but very difficult for you as a lawyer to say, well, given the fact that there is a great risk of storm damage in 20 years' time, etc., this is what you do, or this is what you should do, or you shouldn't be buying this property. I don't think we can do that. So when should climate change be considered for a commercial property lawyer? When we're onboarding the client, when we're scoping the retainer, telling the client what we're going to do with regard to climate change, and flagging up the fact that climate change reports are now available, either separately or as part of our environmental search and report. I think when we report on title, we should highlight to the client that either we've recommended or suggested the client obtains a climate change report and the client has declined, or alternatively, the client has obtained a climate change report which we provided to the client, and highlighting to the client that if they have any questions or queries in that connection, they should take those inquiries or queries to the report provider. And on file closure, I think we should again just be drawing to the client's attention the fact that there is a climate change report that has been obtained, telling the client to keep it safely, advising the client that it may be necessary in the future for that report to be submitted to insurers, to lenders, or to a prospective buyer. Why am I sort of concerned about this? Well, if you look back in history, and not too far back in history, you'll see a number of things. Firstly, if we were speaking about chancel repair liabilities 50, 60, 70 years ago, I'd be saying to you, well, it's quite an interesting sort of landlord topic, quite an interesting archaic concept, but I wouldn't be saying to you, unless you investigate chancel repair liability, you could be sued in negligence. One case, the Aston Cantlow case, and all changes. A whole new industry is created. Chancel repair liability, indemnity insurance, chancel check searches, etc. When I first started in practice, environmental searches and reports would be something that would be mentioned to commercial clients, certainly not residential clients, and certainly not mentioned to all commercial clients. If you had a client buying a bus depot, or buying a sort of brownfield site, it might be mentioned, but certainly it wouldn't be given the emphasis that it's given today. As far as drainage and water searches are concerned, they wouldn't be nowhere near as sophisticated as they are today in the past. So what does history tell us? It tells us that due diligence evolves and will continue to evolve. And therefore, whereas today we might be thinking, well, yeah, climate change is an issue for the planet, an issue of concern, but not really an issue for conveyancers, I think is dangerous. And with Law Society guidance now available to us, it increases in its intensity with regard to that danger. So the Law Society says, hey, be aware of climate change. Tick, we are. I'm saying be aware that we can now get climate change reports. The climate change report, according to the Law Society, will provide information concerning risk. And the interesting thing I've taken from the guidance is that the Law Society divides that risk into 3 areas. So the environmental impact of climate change that could affect value or use of property, be it residential or commercial. So let's drill down for a moment on that. Value. If we've got a property that's prone to ground movement issues, it will impact on value. It will impact on use. If we've got a property that's vulnerable to storm damage, tree falling, etc., then again, there's risk to life and limb and risk to damage to the property that could impact on our industrial or commercial output. As far as transition risk is concerned, this is something I hadn't thought about, but when you do think about it, it makes sense. If climate change goes the way it's going, and if government does what it's intending to do with regard to eliminating or reducing risk, there is a greater likelihood going forward of legislation acts of parliament or regulation that will impact on property use, requirements for heating, requirements for energy efficiency, requirements for electric charging points for vehicles. All manner of different policy or legislation could be introduced that will impact on property ownership. So commercial property being required to have parking places and electric charging points for vehicles. Obligations on buildings, commercial buildings, to be more energy efficient. Restrictions on types of heating or use of heating. All of these things could impact on use of commercial property, of expenses incurred relating to the management of that property, and then value of the property for sale or security purposes. So this transition risk, as I say, wasn't on my radar till I read the Law Society guidance. Liability risk, recovery of damages for loss as a result of physical or transitional risk being made by neighbours or being made by third parties, again, was something that is obvious. So what I'm saying with regard to climate change is this. One, tell clients that a climate change report can be obtained. Two, explain to clients that you won't be able to give specific advice relating to climate change and climate change issues. All you can do is highlight that the Law Society envisaged 3 types of risk that the client needs to be aware of. And I think that's it. So it's not scary. It's not something that I think should cause sleepless nights, but it is something that I think you need to address. I don't think now you can say to a commercial client, I'm not going to deal with it at all. I think if you're adopting that strategy, at the very least, you've got to say to the client, I can get a climate change report for you. And I think if you're doing that, it's a good idea just to say, look, the Law Society say these are the risks that potentially could impact on you with regard to your ownership. So is there a risk for conveyancers? Well, yes, there is. I think a failure to advise a client that there is a risk, that an environmental search will cover the risk, or a climate change report can be obtained to deal with it, is important and could lead to liability. Failing to advise the client about the risk revealed by a climate change report at this moment in time isn't an issue, but do make it clear that you're not going to be giving that advice. Again, in a commercial context, we are able, as I mentioned in my introduction, to apportion risk. And this is a prime example, a practical example of doing that. If we become aware of anything else that's revealed in due diligence that impact or could impact on the client and is associated with climate change, I think we're obliged to do that. And the reason for that is, remember I said again in my introduction, this idea about the overriding principle of reporting to clients anything that's materially adverse to their acquisition. Well, Stephen Troman, the guy that wrote the opinion on climate change last year, talks about something called the adjacent tooth principle, a bit of dentistry for you on a Wednesday morning. And what he said was this: the position is that if you are a lawyer and you're doing some work on a client's behalf with regard to due diligence, as here, and you become aware of something that isn't directly relevant to your retainer, but would impact on the client's decision whether or not to proceed or not, you should draw it to the client's attention. And therefore, I attach that concept to that penultimate point. If my due diligence reveals a risk with regard to trees falling due to storms, etc., then I think it's important that I mention that to the client in my report on title. Surely a surveyor or valuer would do it, and surely a client who inspects target property is going to see the issue. But again, I think it's important that we draw it to the client's attention. Failing to advise a client about climate change generally, I don't think would lead to liability, given the current Law Society guidance. When we get the new or detailed guidance from the Law Society about transactional property law issues, that position may change. So sources for climate change, TA forms, inquiries before contract, client inspections, searches, etc., all of that becomes important. The climate change report that you will see will contain information concerning ground conditions, exposure to storms, coastal erosion, flood risk, etc. As far as scoping the retainer relating to climate change is concerned, I've dealt with this slide, to be honest with you. I think we limit the retainer so that we're not giving advice on climate change, that we're highlighting to the client that we can obtain a climate change report and highlighting the general risks that are identified by the Law Society's guidance. What can we learn from case law relating to the retainer? Well, it's just this general point about the fact that no matter what we say in the retainer, there is a sort of fundamental duty, overriding duty with regard to reporting to clients issues that could be materially adverse to their decision to purchase. Right, climate change and reporting on title. What do we do when a climate change report isn't produced? When the client says, thanks, but no thanks. I would just repeat the fact that you've advised that it's available. And I would repeat the fact that in your engagement or retainer letter, you've drawn to the client's attention the availability of the report and the general risks that's associated with climate change. When the report is produced, you would just simply refer the client to it. And again, all we're doing here is providing the client with information. We're not really providing explanation and advice other than general advice relating to general risk. Covered all of those things, so we needn't worry about that. Let's move on. Lenders, do be careful with checking instructions from lenders in connection with climate change. Should a climate change issue be reported to the lender? Well, if the client gets a climate change report and there is an issue in that report, then assuming that you're acting for the lender, I would disclose it. Of course, it may be necessary to ask your client for authority to disclose. And what about insurers? Well, again, insurers and indeed lenders are switched on to climate change. They're probably ahead of the game, to be honest with you. And again, they're going to be concerned about climate change issues that may impact on insurance premiums, etc. Next thing I want to talk about is the next thing in the notes there concerning client inspection. In connection with conveyancing transactions, client inspection is important. With regard to commercial transactions, it's potentially more important than in a residential context. Why? Well, firstly, if we're buying commercial property, we've got to be aware of the risk of commercial tenancies or commercial occupation that gives rise to a tenancy that's 54 Act protected. So in a residential transaction, it's going to be glaringly obvious in most circumstances that there's someone in occupation in addition to the sellers, and the sellers are likely to volunteer that information. In a commercial context, that might not be the case. So clients should always be encouraged to inspect before exchange of contracts. And the purpose for that inspection should be to check the information in the CPSE inquiries and any additional inquiries is accurate. So again, I repeat the point about using CPSEs as a checklist. Secondly, to identify the physical extent of the property, the plans, the description of the property in the contract or agent's particulars, is that consistent with what our buyer client sees when they inspect? To check the state and condition of the property, the caveat emptor principle, and significantly to check for overriding interests. So third-party rights, easements, etc. Leases with a term of less than 3 years are overriding and will be binding on a buyer. So we've got to arm our client buyer with what we want them to look out for and what we want them to report to us about. We've got to be careful as to who in our client's organization actually inspects to make sure that they're aware of what we're looking for. And I think it's important also that the client understands that they need to report to us anything that they see. They are, in essence, our eyes and ears. To what extent would I, as a commercial property lawyer, inspect a target property? Well, can I tell you that as a matter of course, I would inspect. It wouldn't be a formal inspection normally. If I'm in the locality, I'll have a look at it and just have a wander around and just make sure that I understand and see how it fits and see if there are any issues. If my due diligence reveals issues, then I may be inspecting for that purpose. An important point here, if you are inspecting a property on a client's behalf, it's important that you let the client know that you are going to inspect and what you're looking out for. I hark back to the point that I made about scoping the retainer and monitoring the retainer. In the retainer, I'm telling the client, I will not be inspecting this property. If I'm now, for whatever reason, going to inspect it, I need to tell the client that I am, and I need to tell the client what I'm going to be looking at. It's very, very important. And then reporting to the client what I see when I've inspected. Commercial clients need to understand that they're bound by anything that they actually see. They're bound by anything that they ought to have seen on a reasonable inspection, the concept of constructive notice. And they're also bound by anything that a third party who inspects the property on their behalf sees. So the concept of imputed notice, surveyor, valuer, managing agent, lawyer that inspects on the client's behalf. Client inspection is so important. It's one of the things that I think is overlooked when reporting on title. So in the report on title, I would always have a little paragraph about client inspection. I asked you to inspect the property you carried out. You tell me that you had carried out an inspection. You also told me that nothing was revealed to you during that inspection that should be of concern to me, so that we're spelling out to the client that they've done what we've asked them to do and they haven't reported back any issues or problems. Clients should also inspect before exchange, in my view, or at exchange, where premises are empty or where premises are prone to vandalism or damage. The reason for that is your client is fixed with knowledge as at exchange of contract as to the state and condition of the property. If there's a material change in state and condition between exchange and completion, your client theoretically is entitled to rescind as a buyer. But if your client has no knowledge of what the state and condition of the property was at exchange, that opportunity is going to drift by, unfortunately. So client inspection, actual notice, what do they see? Constructive notice, what would a reasonable inspection have revealed? It follows from that, you should be telling the client what to do when they inspect. What is a reasonable inspection? And it's also important to ensure that the client is reporting to you. So clients should be told what a reasonable inspection entails, and clients should be told when they have inspected to report back with what they see. The next thing I want to talk about is something I touched on a little earlier when we talked about climate change, and that's the provision of advice. Generally speaking, as a commercial lawyer, you are not required to give advice to clients about the commercial wisdom of a transaction. However, where a transaction is so obviously detrimental to the client or so obviously lacking commercial or legal logic, then it's important that you intervene. You can't just simply sit back and allow a client to commit to a ridiculous deal. The sort of spectrum of the need to advise depends on the sophistication of the client. So the 19-year-old lady that's just left school or just packed in university on the basis that mum and dad are buying a hairdressing salon, and this is her first acquisition of property of any kind, will obviously require more hand-holding than the sophisticated 60-year-old managing director of a property company that's been buying and selling commercial property all his or her life. But it is important to understand that if a deal is generating risk, it's important to highlight to the client the existence of that risk. Carradine Properties against DJ Freeman sort of confirming that principle. And I've already mentioned to you this idea of the adjacent tooth principle, that as a commercial property lawyer, you can't simply hide behind your retainer and say, well, yeah, I'm aware of that, but I don't have to tell you about it because my retainer enables me to sort of dodge that one. That's why I go back to those principles that I mentioned relating to climate change. So the next thing I want to do is to have a deep dive into restrictive covenants and reporting on title. Why do I want to do this? Because I think it throws up a number of interesting issues with regard to the work that you and I do in connection with commercial transactions. So we're going to start off with some basics relating to restrictive covenants, and then we're going to have a look at how that impacts on the work that we do. And the first thing to state here is that, remember, a restrictive covenant is simply a contractual obligation, that's binding on the original contracting parties, and it has the potential to bind subsequent owners of land that benefits or is burdened by the covenant. Therefore, if we are acquiring land on behalf of a commercial client, it's important that we ascertain the client's objective. Why are we buying this property? Then we assess if there are any covenants that will impact on that objective. And then we ask ourselves, to what extent are we required to determine the enforceability of those covenants? Are we simply going to tell the client about the existence of covenants and then tell the client we haven't investigated whether the covenants are enforceable or not? Or are we actually going to investigate enforceability? If we are investigating enforceability, for what purpose? Is it going to be necessary to think about buying out the covenant? Is it going to be necessary to think about an application under Section 84 of the Law Property Act 1925 to vary or remove the covenant? We need to think about it. We need to assess just what's being done. Now, before I leave this slide, I have to tell you that you're perfectly entitled in your retainer to simply advise the client that my role is to tell you about the covenants that are evidenced on the title that's being disclosed by the seller. You can simply do it and leave it at that. But I think as a commercial property lawyer, particularly where a client's objective is likely to be impacted upon by a restrictive covenant, we've got to go more than that. Just excuse me a moment. My partner's little dog is in the building at the moment and she needs to be out. I'll just let her out for a second. If anyone wants to buy a Cavalier King Charles Spaniel, she's for sale. But don't tell my partner, God bless her. Anyway, back to this stuff. So important to think about what we're going to do with regard to covenants. Are we just simply going to be superficial and say, you're buying land that's burdened by covenants and here's a list? Or are we going to do more than that? Our retainer will clarify the position. If we're going to have a deep dive into the covenant and the client is telling us, or we think the covenant's going to impact on objective or perhaps impact on value, then we need to ask ourselves, are we bound by the covenant? So the first thing to do is look at the covenant. And a word of warning. There's a case called Dennis against Davis, which I think was a High Court decision where you had a nuisance covenant that was clearly designed to prevent neighbours doing unneighbourly things. But what the court said was the wording of the covenant was sufficiently extensive to preclude a neighbour having construction work done, building an extension. Because the judge said, temporarily, the builders, the noise, etc., will be a nuisance, and therefore this covenant prevents it. So always have a look at the wording of the covenant and just be careful. Particularly nuisance covenants, their scope can be very extensive, far more extensive than you might at first sight think. Clearly, the covenant is likely to bind the original covenanter while the covenanter owns the land. Could it bind successors in title? Well, it depends, doesn't it? If the covenant simply is imposing personal obligations, then it can't. If the restrictive covenant is protected, and it's protected by way of notice if the land is registered, D2 land charge if it's not. And is there land in the vicinity that benefits from the covenant? Now, note that I'm saying in the vicinity. It doesn't have to adjoin or abut the land that is burdened by the covenant, but there has to be land that benefits. Last point, important. If a restrictive covenant is anti-competitive, then there is the potential for it to be challenged. There was the Humberside Terminals case. I don't know if you saw that a few years ago, where the court emphasized that a restrictive covenant could be anti-competitive and could be capable of being challenged. In the Humberside case, the covenant was also challenged in connection with a 54 Act renewal issue. Anyway, watch, if a restrictive covenant is anti-competitive, then it is possible for that covenant to be subject to application for removal. So, important points. How can you protect a restrictive covenant? Well, D2 land charge if the land is unregistered. Agreed or unilateral notice in the charges register of the land which is subject to covenant. 2 or 3 points in connection with this bullet point. Point number 1, whenever you're protecting an interest in land and the land is registered, You can protect that interest in land by the use of an agreed or unilateral notice. Agreed notices afford greater protection than unilateral notices. Agreed notices do not need the agreement of the registered proprietor. It is simply necessary to provide the land registry with evidence in support of your contention that your client has an interest in land to get an agreed notice placed on the charges register without the proprietor's consent. Second point with regard to notices is that where you are looking at protecting an interest in land, if the interest in land has overriding status, it's that status that affords it protection, and you shouldn't use a notice to substantiate that protection. Next point, if interest in land can be protected by restriction, you should use a restriction rather than notice. And the third point, going back to my first principle with regard to third bullet point on this slide, agreed notices afford greater protection than unilateral notices because unilateral notices can be challenged. That challenge can be by the proprietor of a charge, anyone with a prior registered notice, or anyone with an interest in the land. So the challenge opportunity does not just apply to the registered proprietor. The last point on this slide, I think, is so important. A notice doesn't validate a restrictive covenant. It doesn't guarantee that it's enforceable. It doesn't legitimize enforceability. To get a notice to protect a restrictive covenant in the charges register of a title, all I have to do is to provide the land registry with evidence as to its existence and complete the appropriate application. The land registry will not do what we just did, if we go back to our previous slide, and carry out that exercise to determine if land is burdened by the covenant. Nor will it perform the next exercise to see if the land that purportedly benefits from the covenant in fact benefits from it to make it enforceable. So if we look at this slide, who has the benefit of the covenant? Well, potentially a successor in title. If the covenant was expressly or in part for the personal benefit of the original covenantee, then won't apply. If the retained land isn't capable of deriving benefit from the covenant, it won't apply. Where retained land can't be identified either by deed or other intrinsic evidence, it won't apply. If the covenant is expressed to benefit the retained land as a whole and the land has been subdivided, it's not going to apply. And the owner has acted in a way which means it's inequitable for the covenant to be allowed to be enforced. Let's just have some explanation and exploration of some of these points. This retained land point is so important. Where you're creating a new restrictive covenant, do make sure that you are meticulous in clarifying the area of land that derives benefit. We're speaking to a KC earlier this year who did some training about restrictive covenants, a guy called Christopher Heather from Tanfield Chambers, I think it was, yeah. And he was saying that one of the things he notices with regard to practitioners is a sort of an imprecise stance being taken with regard to identification of retained land. You've got to be meticulous to clearly identify it. And importantly, penultimate point on slide, you've got to make sure that the covenant is expressed to benefit the retained land or any part of it. And particularly where you're subdividing land that has the benefit of a covenant, if the covenant isn't expressed to that extent, the subdivision could mean that enforceability is lost. This last point is something I've been doing some work on recently. How many times have you acted for someone who's bought land and that land has the benefit of a restrictive covenant? In those circumstances, I am confident that you will tell the client that the land that they're buying has the benefit of a covenant. I'm convinced of that. But how many people would say to the client, it's important you understand that this covenant is not set in stone? One, the owner of land that is burdened by a covenant could apply under Section 84 to vary or remove covenant on application to land tribunal. Do you tell clients about that? And secondly, I think this is even more important. that as an owner of land that has the benefit of a covenant, it is imperative that you are aware of the fact that you could lose the right to enforce the covenant due to lack of action. So if your neighbor who owns land that is burdened by the covenant submits a planning application, and that application relates to development that would breach covenant, or where you are aware that the neighbor has instructed a groundworks company to go in to undertake site investigation, then in those circumstances, a lack of activity, a lack of challenge, a lack of an email, a lack of instructing solicitors, delay, could mean that it would be inequitable to enforce. Remember, delay defeats equity. Remember, an injunction would be an equitable remedy, therefore could be lost due to delay. I see frequently situations where a commercial client is buying land, has the benefit of the covenant, is told about the covenant, but isn't told about those issues. Do check your report on title where you're discussing the benefit of a covenant to make sure your client is aware of the fact that enforceability is not guaranteed. What is the position if we're buying land and we think it has the benefit of a restrictive covenant, but either we can't investigate or we have investigated, or where the client just says, well, all right, or we've not adopted the sort of the approach that I mentioned earlier, just to tell the client, hey, there are restrictive covenants that affect the land. When might defective title insurance be necessary? Well, in any of those three situations. A number of things that I think are important, however. One, beware undertaking investigation to determine about the enforceability of a covenant. That investigative process could highlight to third parties the existence of the problem or the existence of your contemplating taking out a policy. In either case, the disclosure, the awareness of third parties to what you are doing or intending could potentially invalidate a title indemnity policy that you obtain. At the moment, I've done quite a bit of work with regard to auctions and online auctions. If your client is selling a commercial property on an online auction, and you disclose, or the auctioneer disclose in the contract pack or the online auction pack, that there's a defect in title, or a defective title insurance policy in place, or that there are unknown restrictive covenants or restrictive covenants where enforceability is unclear and a defective title insurance policy is in place, that reference to the risk or the policy in the contract pack will constitute a disclosure to the world at large that will invalidate the policy. It is possible to tell a buyer, a prospective buyer, of the existence of the policy or the existence of the defect, but you're entitled to do that as the transaction progresses. You can't, and this is the way insurance would argue, flag up to the world at large the problem. And with regard to an online auction, or indeed a face-to-face auction where there's an online auction pack available, anyone can have a look at that pack, and anyone in those circumstances might be able to enforce a covenant or might be able to notify someone that can enforce it of its existence. So be careful about undertaking investigation, be careful about disclosure. The next point with regard to unknown restrictive covenants or problematical restrictive covenants is what would be an appropriate level of indemnity. Is an appropriate level of indemnity the purchase price that we're paying for the property? Is it its market value? Is it its potential development value? Is it the amount of loan that we're securing on the property? Could be any of those or all of them. The important thing to understand and appreciate, however, is this. The level of indemnity is always going to be an arbitrary sum. It is impossible to assess in 2023 what risk or vulnerability your client is exposed to in connection with a claim being made relating to the policy. It might be that a claim is brought and a covenant is bought out for £50,000. It might be that the person who has the benefit of the covenant takes action that ends up in the Supreme Court, where the legal costs are £500,000. And then there's the diminution in value to boot. Most policies will cover diminution in value. Some policies will cover costs. Some policies will cover the cost of making application under Section 84 to vary or remove covenant. You need to check. But you need to check the appropriate level of indemnity and warn the client. I would always warn the client that the level of indemnity is an arbitrary sum that may not properly represent the loss the client could sustain. Should a loss be taken out by the seller or the buyer? Well, this is an interesting one. Where there's a problem with regard to title, clearly it becomes the seller's problem. So my stance there is the seller should pay the premium. But who should take out the policy? Well, I think the buyer should take out the policy, because there's an incentive on the seller being restrictive with regard to the truth or information that they disclose to an insurer. Because surely there's an incentive on the seller to get a policy. And there's no real incentive on a seller, particularly an unscrupulous seller, to make a full and frank disclosure to the insurer on the basis that that may increase premium or may mean the property cannot be insured. So there's a risk that the seller tells the insurer the bare minimum to obtain a policy. Insurer then at a later date finds out that the policy was obtained under false pretenses, invalidating the policy, meaning the buyer's high and dry. At least when the buyer takes out the policy or the buyer submits the application, the position is the buyer will be able to disclose its own knowledge and will hopefully make a full and frank disclosure. So the possibility of the policy being invalidated is lost. Where the seller is taking out the policy or there's a pre-existing policy, you either want warranties in the contract that the policy remains live and active, the premium has been paid, the seller is not aware of anything that could invalidate the policy, or better, in my view, you'd perform a due diligence exercise with regard to the insurer. So you ask the insurer to confirm the policy still exists, the premium has been paid, and ascertain what's been disclosed by the seller to the insurer when the policy was taken out. It is a useful means of plugging gaps, but the important thing with regard to any title indemnity insurance is that the problem remains. We don't know whether this covenant is enforceable. There are unknown restrictive covenants recorded on the title, and no one knows what those covenants are. The client needs to understand that this is a solution, but the solution is not a resolution to the problem. The problem could repeat itself, could resurrect itself when we come to sell site or when we come to refinance site. What do policies cover? Well, they may cover damages or compensation due resulting from claims. They could constitute costs incurred with regard to demolition or alteration of the property. Loss in market value between market value of covenant and open market price at the time of insurance. It is important that it may also cover diminution in value, as we mentioned. It may also cover that the insurer will fund an application under Section 84 of the Law Property Act 1925. To that end, we will be looking at Section 84 before we finish this morning. I repeat the point that a restrictive covenant has to be protected by notice in the Charges Register of the title of the burdened land, but that protection doesn't mean the covenant is enforceable or not. That's the important point. A lot of practitioners think it's noted on the title, it's in the Charges Register, therefore it is binding. Remedies for breach of covenant. Well, first of all, the most common type of remedy will be an equitable remedy, an injunction or specific performance. And the point I made about delay is important. Also important to understand and appreciate that clients must come to equity with clean hands, leading me to a very important point. As transactional property lawyers, we may become aware, having acquired property or having owning property that's benefiting from a covenant, we may become aware of a situation and maybe the first point of contact where negotiations begin with regard to variation or removal of covenant. or we may be sort of continuing to act for a developer who's building a site out or undertaking development works. The point I want to emphasize is this: be careful where there is the makings of a dispute. Having spoken to 3 sets of different counsel, all of whom have ended up in the last 12 months in cases before the Court of Appeal or the Supreme Court, absolutely essential that you have a look at emails or correspondence or the conduct of your client and ask yourself, how does this look in the cold light of day? How would my email look if it's being read by a judge in the Court of Appeal or Supreme Court? Has my client behaved reasonably? There was a case called the Alexander Devine case. It involved a children's cancer charity and a developer that was involved in a cynical breach of covenant, carried out development in the full knowledge that there was a covenant preventing it, just went full steam ahead and built houses, then applied under Section 84 for variation of covenant. And the fact that this developer was cynical with regard to simply breaching the covenant, was blasé with regard to knowing that there were 2 entities that could enforce the covenant, but hadn't even embarked on negotiating with them about anything, all of that stood that client in particularly bad stead. So have a look at the emails, and it is tempting to fire off a nasty email. It is tempting to say, no, we're not prepared to negotiate or communicate or talk about an issue. I would always maintain, try wherever possible to appear reasonable, try to open doors with regard to communication, explore settlement, explore satisfactory conclusions without immediately embarking on litigation. I'm sure that your litigation colleagues will give you sort of similar advice, but often it's you as a transactional property lawyer that sort of are first to get an inquiry from a client that you've acted for on a purchase or on a sale saying, hey, what do I do? And again, it's tempting to sort of fire off an email or to do something that could have fairly drastic consequences going forward. On the issue of damages for loss, there's a very important point. I'll just go back to this slide, sorry. Your client's claim for damages is likely to be relatively small. So what loss have you sustained as a consequence of next door building 12 houses instead of 6? So it's not really damages that's going to be the key. It's seeking an equitable remedy to stop conduct or to require conduct to be undertaken. Section 84 of the Law Property Act 1925 allows an application to be made to Land Tribunal to vary or remove covenant. And what I've done on slide here is shown you the most common grounds and highlighted in bold called ground AA, which is the most common ground that's used. The covenant would impede a reasonable use of the land and confers no practical benefit of substantial value. So 2 limbs there, impeding a reasonable use of the land and conferring no practical benefit of substantial value to the land that benefits from the covenant, or is contrary to public interest and can be adequately compensated in money. The important point here is to assess what a reasonable use of the land is. Planning permission is not of itself firm evidence that whatever permission is being granted is a reasonable use. What you've got to do is look at what the covenant was designed to do when the covenant was created and assess whether in 2023 that covenant is now preventing reasonable land use and whether the covenant is not in fact providing benefit of substantial value to the land that is benefiting from the covenant. In that latter point, of course, where the land is located, the issue of vicinity becomes important. If the land is 2 miles away and all the land adjoining has now been subject to residential development, would the covenant now confer any form of practical benefit on the land that's 2 miles away that is now surrounded by residential development when the intended use of the land that's burdened by the covenant is residential development as well? Contrary to public interest, affordable housing, commercial activity that will generate employment, etc. Again, contrary to public interest and can be adequately compensated in money, this compensation point becomes really interesting, and we're going to have a look at that on the next slide. Where parties agree expressly or impliedly to discharge or modify a covenant, that's why you've got to warn clients who own land that benefits from a covenant about they've got to be careful about what they're doing. So expressly agreeing to development or impliedly agreeing to development or to discharge or modify the covenant will cause problems. And C, discharge or modification won't injure the persons entitled to the benefit of the covenant. Again, you're talking about land ownership and where that land ownership is, where the vicinity, in what is the vicinity within which the land is situated that benefits from the covenant. Item A, changing the character of the property or neighborhood or other material circumstances, rendering the restriction being obsolete. Key here is getting evidence of land use from surveyors and valuers. The point I would make with regard to a Section 84 application is this. If you are contemplating it, land tribunal applications are notoriously difficult, necessary to prepare long and hard to get all your evidence together, and probably worth instructing counsel. Certainly not a matter for a transactional property lawyer to become embroiled in. Either your property litigation team or counsel would take the lead in connection with such applications. I said about compensation, and so come back to this. When I first started doing this sort of work, the position was that if I acted for a client who had land that benefited from the covenant, then the position would be that I would be thinking, if the applicant is successful in having this covenant varied or removed, my client will get a windfall, because my client will be entitled to damages, and those damages will be a third of the value of the uplift in value of the land that was burdened by the covenant. So let's look at an example. The land currently is agricultural or semi-derelict and worth £30,000. The land, if it is, but is burdened by a covenant precluding residential development. If the land is subject to planning permission for residential development, that land now becomes worth £1 million. I would, in the good old days, potentially be entitled to a third of the uplift in value. However, today, what the Land Tribunal may well say is, well, all right, Ian, that land that is burdened by the covenant now rockets in value as a consequence of this application. But you're not entitled to a share in that uplift. What we are required to do is to assess what is the diminution in value of the land that has the benefit of the covenant, in other words, your land. So what would the damage be, and how do we assess it? And the damage may well be temporary nuisance as a consequence of construction nearby, potentially issues with regard to flooding, but the actual compensation that you could be awarded as a consequence of those two circumstances could be significantly less than a share in uplift in the land that was burdened by the covenant. And that's the important point. Don't allow clients to sort of get lulled into the opportunity for a huge windfall. It may not, in fact, arise. From a commercial properties lawyer's perspective, the concept of overage is a nightmare. Why? Because clients who are selling land love the idea of a second bite of the cherry, love the idea of overage, but problems with overage, number one, how on earth do you protect it? There are so many options and ideas sitting out there to protect overage. The problem with most of those systems and processes do not, in fact, generate security. So let's have a look at what we could do that would protect overage completely. Well, firstly, selling a leasehold title and with an option to acquire freehold when overage is paid, or taking a first legal charge. Both of those options are going to be unacceptable to a developer, because he's going to want a freehold title and he's going to want to use the land that's being acquired as security for funding his development. So other options: contractual obligations, fine. Reserving easements, ransom strips, fine, but all capable of circumnavigation, all possible to escape the potential for paying overage. What have I seen? Reservation of airspace, ransom strips, reservation of easements, taking second charges, all possible, but all potentially subject to the owner of the land who acquires the land sort of navigating a way around the overage payment. So, in short, what I would say is, with regard to a restrictive covenant being used to protect overage, our problem is the Section 84 application to vary or remove. There was a decision of Land Tribunal that said a person that had land that had the benefit of a restrictive covenant to protect overage could not be compensated where the covenant was varied or removed because of the loss of that security. That's the point with regard to using a restrictive covenant, to protect overage. So let's drill down one more time with regard to restrictive covenants. Do we just simply provide a client with information? Here's a list of covenants on the title, without any sort of attempt to determine whether the covenant impacts on objective or is enforceable or not? Do we provide explanation and ascertain if the covenants are enforceable? And are we going to provide advice? Is the advice we haven't checked? Is the advice we have checked and are of the view that the covenant is or isn't enforceable? Or can't we tell? In which case do we think about title indemnity insurance? If we're advising on restrictive covenants and we haven't checked, explain to the client this covenant could be enforceable. It could impact on value or use or enjoyment. If the covenant has been checked, if we are saying it is enforceable, who can enforce it? Are we saying, could it be bought out? And who is going to approach the owner of the land with the benefit of the covenant for that purpose? Could an application be made under Section 84 of the Law Property Act 1925? Are we charging for investigative work that we're undertaking with regard to Section 84? Are we instructing our property litigation team or counsel to assist? If we're not sure whether a covenant is enforceable or it's not enforceable, are we really sure? Do we need indemnity cover? I think in those circumstances, if we say it's not enforceable, it's always worth thinking about a policy, just to sort of protect us and protect our clients, subject to those issues that I mentioned earlier about what the policy does and what the policy can do. So we've covered that. So what I want to do now is talk about the Building Safety Act 2022 for the last part of my presentation. The Building Safety Act 2022 became law in April last year. It is an immense piece of legislation, vast in its scope and extent, badly drafted, incomplete, and subject to numerous regulations, which again are to an extent incomplete and confusing. So, if you're acting for commercial clients, what do you need to know? One, the Act creates a new regime called the Building Safety Regulator, whose responsibility includes building regulations and includes management of construction or renovation of buildings, particularly higher risk buildings over 18 meters in height. So the Building Act 1984 is amended to enable the Building Safety Regulator to participate in the planning and development process, to regulate types of material, to approve construction, and to consider building safety issues. The Building Safety Regulator also is required to create committees of developers, of landlords, of leaseholders, to obtain feedback with regard to building use and building safety risk. It also acts as a police force with regard to enforcement of certain parts of the Act. The Building Safety Act under Part 4 highlights high-risk buildings, buildings over 18 meters in height, and imposes a burden on accountable persons, normally the landlord, with regard to safety measures relating to such buildings. Now, when we talk about safety measures, monthly inspections, provision of information for firefighters in the event of emergencies, undertaking risk assessments, making sure that leaseholders and visitors are aware of evacuation procedures, inspecting doors to flats and apartments to make sure that they are fire safe. So we're not talking about simply paying lip service to policy, we're talking about a lot of practical work. As far as that work is concerned, the Building Safety Act creates a new regime for what are called building safety charges. Building safety charges are outside the service charge regime, meaning that landlords can collect them without challenge or deduction, provision for ADR or dispute resolution where leaseholders wish to challenge them, but imposing obligations on leaseholders to pay building safety charges. The Building Safety Act changes the Landlord and Tenant Act 1985 by including, the concept of building safety charge and removing from the Landlord and Tenant Act 1985 challenges as to reasonableness of building safety charges. So creating a new regime for building safety charges, costs that landlords incur relating to building safety, compelling landlords to produce work and to undertake work, but allowing landlords to recover cost. In addition to that, for higher risk buildings beyond 18 meters, imposing implied terms into residential leases. Those implied terms on landlords relating to building safety measures, and building safety measures are measures relating to not just fire safety, but construction issues, and imposing obligations on leaseholders to comply with landlords' requests relating to building safety measures and to pay building safety charges. So it doesn't matter what it says in the lease, there are now implied terms in connection with higher risk buildings over 18 meters in height. There is now a new form of LPE1 issued as of January this year, which includes information now with regard to landlord and leaseholder deeds of certificate in relevant buildings. More on that in a moment or two. The Association of Residential Managing Agents, or ARMA, has guidance for landlords and managing agents with regard to the production of LPE1s, currently suggesting that landlords insert disclaimer in connection with an LPE1 for information being produced relating to building safety. Significantly, there's new guidance that's awaited with regard to the new form of LPE1 from ARMA. We haven't seen that yet. The LPE1 now will require a landlord to produce a leaseholder deed of certificate or a landlord certificate where a building exceeds 5 stories or 11 meters in height. The idea of a leaseholder deed of certificate is self-certification. The leaseholder, as of the 14th of February 2022, confirming that they had a qualifying lease at that point for the purposes of the Building Safety Act. A landlord certificate is quite a complex document. I saw one last week which ran to nearly 80 pages of very sophisticated accountancy information and information concerning renovation remediation work relating to the building. A landlord is required to produce a certificate within 4 weeks where a leaseholder asks for it, where a leaseholder notifies the landlord that they're selling their flat or the apartment, or where a landlord has incurred or is incurring works of remediation that are covered by the Building Safety Act. In other words, that they relate to a relevant defect. A landlord certificate will also include details of what actions have been taken by the landlord relating to remediation, claims against relevant contractors, and claims being brought in connection with government schemes. It will also contain details of any enforcement action being taken by the building safety regulator against the landlord. The LPE1 may well have a disclaimer, as I mentioned to you, so do look out for that and see if you're acting for a landlord whether a disclaimer would be appropriate, and have a look at the ARMA guidance to see what the new guidance is saying in that regard. The problem with the Building Safety Act, as I've mentioned, is that it's a vast piece of legislation and not all of it is currently in force. The Building Safety Act incorporates some of the remediation necessary courtesy of Fire Safety Act and Fire Safety Regulations. The Fire Safety Amendment Regulations 2022 became law in January of this year. The law relating to building safety for higher risk buildings and buildings beyond 11 meters or 5 stories in height is over and above the information that is necessary in connection with the production of EWS1s for fire safety issues. Landlord certificates and leaseholder deeds of certificate, the Act triggers when they are required. There isn't any criminal sanction for the failure to produce them, but there are drastic consequences for both landlord or leaseholder where a landlord certificate should be produced or a leaseholder deed of certificate should be produced. One of the problems that residential conveyancers have are lenders' instructions when acting for purchasers. So you're seeing a lot of lenders, firms, a lot of solicitors acting for leaseholders, refusing to act in connection with sales or purchases of property that's caught by the Building Safety Act. And the reason for that is that conveyancers are worried about risk, advising a client that the Act applies when it doesn't, or the Act doesn't apply when in fact it does. To an extent, everyone is getting very concerned about Schedule 8 of the Building Safety Act. The balance of the Act theoretically applies to any building, no matter what its height, as long as it contains 2 or more residential units. There are additional aspects and features of the Act that apply to higher risk buildings, as I've mentioned earlier, buildings that are more than 18 meters in height. If you're advising landlords, responsible persons, managing agents, and management companies, there's 2 things to say. 1, the Act imposes a whole raft of additional burdens on, in essence, landlords and their agents. 2, where a building is more than 11 meters in height or more than 5 stories in height, if leaseholders have a qualifying lease, they are potentially protected from some remediation costs that landlords could potentially incur. More on that in a second. So, Schedule 8 of the Building Safety Act provides that certain service charge amounts relevant to relevant defects in a building aren't payable. So if the Act applies to a leasehold property, the leaseholder is protected from some remediation costs for some defects. So it is a protection to current and future leaseholders, and is disadvantageous to landlords because the landlord could be incurring an expense relating to a relevant defect that cannot be transmitted into service charge. So what's a relevant defect? A defect which arises as a result of works undertaken in the last 30 years, Defective Premises Act amended to allow a limitation period of 30 years, and causes a building safety risk, a risk to the safety of people, not just leaseholders, in or about the building, arising from the spread of fire or collapse. So note, not just fire safety defects or fire safety remediation. Section 122 of the Act refers to Schedule 8 applying to relevant buildings. So we need to know what a relevant building is. And there we are, Section 117. Self-contained building containing at least 2 dwellings. So we could have commercial and residential use, but as long as there's 2 dwellings in that building, we're caught under the Building Safety Act. And if we're over 11 meters high or contain 5 stories or more, then we've got a relevant building to which Schedule 8 applies. In order for Schedule 8 to apply, our lease has to be a qualifying lease, and Section 117(2) of the Act tells us about that. So we have to have a long lease of a single dwelling in a relevant building, a lease with a term in excess of 21 years. The tenant under the lease has to have an obligation to pay service charge, so we need to see service charge provision within that lease. And the lease has to be granted before the 14th of February 2022. So any new lease that's granted after that date isn't protected by Schedule 8. Importantly, any lease extension where there's a deemed surrender and regrant is not protected under the Act either. The government suggests in that situation that leaseholders ask the landlord for provision in the agreement that the Building Safety Act provisions under Schedule 8 apply, even though in fact the Act does not apply. That's a bit of nonsense for you. We're also told that the government is creating amending regulations that will deal with lease renewal. Item D is important. At the beginning of the 14th of February 2022, so on the stroke of midnight on the 13th, that is the qualifying time, And for a lease to be a qualifying lease, the owner of the lease at that time has to be able to establish that this was the leaseholder's only or principal home. So they've got nothing else. They live here. So item 2 of D then becomes unnecessary in my view. Or 3, the tenant owned no more than 2 dwellings in the United Kingdom apart from their interest under the lease. So if I own 3 houses and I have this leasehold interest, my lease is not a qualifying lease. If my lease is not a qualifying lease as of the 14th of February 2022, then any subsequent owner is not owning a qualifying lease and therefore does not have the protection under Schedule 8. So you've got self-certification as of the 14th of February. If I meet all of these criteria, 117.2, then I've got a qualifying lease that protects leaseholders going forward. If I don't, then I have a lease that's non-qualifying and the protection is not available to subsequent owners of the flat or apartment. So what is the benefit of Schedule 8? Well, first of all, if a landlord or associate is responsible for a relevant defect, the landlord has to pay for it if I've got a qualifying lease. If a landlord has free assets of more than £2 million, then the landlord should pay for remediation. And this applies to any lease, not just a qualifying lease. If a lease has a value below £350,000 in Greater London, £175,000 elsewhere, the lease, if it's a qualifying lease, is below that value, then the landlord can't recover service charge for remediation against the leaseholder. If the service charge relating to remediation exceeds £15,000 in Greater London, £10,000 beyond, the landlord can only recover up to that amount, and that amount is then payable by leaseholders over a 10-year period. As far as cladding remediation is concerned, a landlord can't charge leaseholders for cladding remediation where the lease is a qualifying lease. The landlord can't recover legal or professional services incurred in connection with recovery of remediation costs if the lease is a qualifying lease. Certain costs under the Building Safety Act are building safety charges that aren't service charged, so Schedule 8 doesn't apply. Remember what I said about building service charges earlier, safety charges earlier. And just because I am a leaseholder that isn't qualifying, the landlord can't transmit all costs that he can't recover from qualifying leaseholders against me. If there are 35 flats in the apartment, all I am liable for is my 1/35th share. Other leaseholders will have some protection, but the landlord can't transmit the irrecoverable costs from them from me. There is an important point that landlords need to be aware of and that leaseholders should be aware of. Paragraph 13 of Schedule 8 states that you don't have to worry about condition D in the leaseholder deed of certificate, the ownership occupation point as of the 14th of February 2022, if the landlord has not taken reasonable steps to obtain a leaseholder deed of certificate and hasn't got such a certificate. So it's absolutely essential, if you're a landlord or acting for a landlord, that if you become aware a flat is being sold, that you ask the leaseholder, the seller, to produce a leaseholder deed of certificate. You take the prescribed steps under the Act and reasonable steps, prescribed steps, emails, telephone calls to the leaseholder, asking for the leaseholder deed of certificate. You've got to do that, or you've got to have a leaseholder deed of certificate on your file. If you do, then the presumption under paragraph 13 does not apply, and any leaseholder has to comply with condition D, the ownership occupation point. So landlords should always ask leaseholders for leaseholder deeds of certificate if a flat is being sold. The leaseholder deed of certificate, as I mentioned, is a record of ownership and occupation as of the 14th of February 2022. If the lease is of a flat in a relevant building and it's a qualifying lease, Schedule 8 protection applies. If it doesn't, then Schedule 8 doesn't apply. We know about that, we've just discussed it. Leaseholder deed of certificate, we've got to look at paragraph 13. If a landlord hasn't done his job properly with regard to requesting a leaseholder deed of certificate or having a leaseholder deed of certificate, then the presumption can apply. What's a landlord certificate? A landlord certificate is required where a building's height exceeds 11 meters or 5 stories and requires information from the landlord about their financial circumstances and also information about building safety works, what works have been done or are contemplated relating to the building. A landlord certificate is required where a landlord wants to transmit costs into service charge, remediation cost into service charge, where a leaseholder is selling and notifies the landlord that they're selling, where a leaseholder requires it, or where we're making a service charge demand for remediation costs. A landlord has to produce a certificate within 4 weeks. If he fails to do so, then by default, a qualifying leaseholder is protected under Schedule 8. So it's imperative that we serve landlord certificates when we're required to. If we don't serve a landlord certificate, then we can't recover remediation costs relating to remedial works as defined under the Act. So on a sale, if we don't produce a landlord certificate, the buyer is not going to be liable for remediation costs that have been incurred historically. A landlord could serve a new certificate where he or she becomes aware of new costs, and the leaseholder would be liable for those costs, subject to whatever Schedule 8 protection applies if it's a qualifying lease. Some landlords aren't producing landlord certificates because it's an expensive exercise. Some are not producing them because they can't do it within 4 weeks. And others aren't producing it because they don't want what is commercially sensitive information about the landlord's finances being disclosed to third parties. There isn't any criminal sanction for the failure to produce a landlord certificate. All you're doing is preventing yourself from recovering remediation costs as defined under the Act. Just a quick point, are surveyors and valuers being prepared to give advice concerning building safety issues? No, is the simple answer. Are surveyors and valuers being prepared to confirm the height of buildings? No, in a lot of cases. Interesting point, a landlord is obliged to register a building that's more than 18 meters in height with the Health and Safety Executive. That obligation, I think, is under Section 85 of the Building Safety Act, and you have until the end of October to register. Where registration takes place, I think anyone can safely assume that the building exceeds 11 meters in height and more than 5 stories, and therefore is subject to the Schedule 8 regime that we've looked at. Lenders are being very jumpy about the Building Safety Act and requiring solicitors acting for buyers to verify the accuracy of the content of a landlord certificate and leaseholder deed of certificate. And I'm saying to solicitors and conveyancers acting for buyers, you can't provide that verification. You need to be aware, if you're acting for developers or landlords, that there are 3 government remediation schemes: the developer remediation contract, the pilot scheme for medium-rise buildings, and the Building Safety Fund. There are funds available, but what is available depends on the type and time of application. There is something called the cascade principle devised by the Act, and the idea of the cascade principle is that landlords should look to pursue claims against contractors who did work that requires remediation, firstly. They should then look at government schemes, secondly, and should only, in circumstances where it is impossible to recover from either of those two sources, should look to recover from leaseholders. It is possible for landlords to make remediation orders or to have orders made against them where remediation is necessary. Landlords can also seek remediation contribution orders. So I'm the current landlord. Remediation work that now needs attention was undertaken by a previous landlord. I can ask that previous landlord to assist with regard to my liability. So problems with the Act, all sorts. The Act is very wide-ranging. It's blocking conveyancing transactions currently. It doesn't apply if a building or lease is non-qualifying, and doesn't apply if the leaseholder doesn't provide a leaseholder deed of certificate when they should. And it also would not apply if the leaseholders own the superior title. When I say it doesn't apply if a leaseholder doesn't provide a leaseholder deed of certificate, it wouldn't apply in connection with Schedule 8. Other aspects of the Act would apply. So does it increase the risk of leaseholder insolvency? No. Does it decrease it? No. I think it just maintains the status quo. Leaseholders might make a saving with regard to remediation costs, but are likely to pay more service charge or building safety charges as a consequence of the Act. What I'd like to do now is see if there are any questions. So I'm going to open up the chat facility and have a look to see if there are any questions. So feel free to put any questions in there. If you haven't any questions, or you do have questions that you're too shy to generate, there is an email address that's shown. I'm just going to have a look in the Q&A column. David, right. How does one advisor client wishing to impose overage that device to be used could be circumvented? And consider, David, what you've got to do is you've just got to scope your retainer so that client is told, look, there are a variety of methods of protecting overage. None of them are foolproof. A copy of the slides, Alison. Yes, if you send me an email, I'm happy to do that. I've also,
Ian,
yes, sorry. Okay.
I will be sending out to all attendees a copy of the slides and all the information that they need, if that's okay.
Thank you. What I'll do, Kay, is I'll also give everyone a free copy of the Property Law UK's Building Safety Act publication that came out just the other week. I'll send that to you and you can share that with all delegates. There's another question. If the council own land on either side of an unregistered watercourse, which application can the council make to the land registry in the absence of title deeds assisting? Right, so the council owned land on the either side of an unregistered watercourse, which application make to the land registry? Well, you could make an application for first registration, and you're likely to be registered with a possessory title in those circumstances. That's what I would do. Anonymous, if you send me an email, I'll have a look at that in a little more detail. Kay, do you have any comments to make or anything you'd like to share before we finish?
No, to be honest, I thought it was very thorough.
Try my best.
If I send out all the follow-ups from your notes and all the slides, please, anybody feel free to email me back with any more questions for Ian, and I can just pass them on to Ian as well. Okay. And what I'll do is any questions that I get directly, I'll share with you. I'll anonymize the questions and the answers so you can share them with people. There's one other question that's David sent. I'm just going to have a look at that for a second and then we'll finish. Just bear with me, David. Right, you're acting in a deceased estate. I saw that. Of a flat. Two issues. The unusual definition of the height of the building may or may not be under 11 meters. Just, she owned no other property. Could she be a qualifying tenant? Well, she could be, David. The problem is that you're now going to have to act for the executors who are going to have to complete a leaseholder deed of certificate. And what you've got to do is warn the client about the dangers of producing a leaseholder deed of certificate. If they get anything wrong, they potentially could be sued for misrepresentation. The deceased wouldn't have been if she died on the 4th, so she's already dead as of the 14th of February. Could the executor be a qualifying tenant? The problem you've got there, David, is that the Act is unclear. And this is a dilemma that I've been talking to the government about, and there isn't an answer as yet. The regulations relating to a leaseholder deed of certificate, by the wording that's used in the guidance, assume that an executor could complete it. So, if the deceased had died before the 14th of February 2022, then your client executor would be a leaseholder that could produce a leaseholder deed of certificate once probate's obtained, David. That's be the route to take, I think. Great question, by the way, David. I like it. Not uncommon, to be honest with you, but I've dealt with this question before, and I'm sure the regulations relating to a leaseholder deed of certificate imply that an executor can complete it.
But where you've got someone that died before the 14th of February 2022, the issue is who was the owner or occupant on that date. And I think if she's dead, or he or she is dead, the position is that is the executor the owner or occupant? Well, there's an argument, isn't there, that you only acquire title on the grant of probate. But I think the regs make it clear that you can produce a leaseholder deed of certificate in that context. Thanks for that question, David. Kay, thank you very much for inviting me along today. As always, it's a pleasure. Do have a look, everyone, at Kay's contact details. I'll go back to those again and just show everyone that before we finish. And then I think what we'll do, Kay, is beat the retreat. And I'll just go right the way back and find the slides. Where are we? We're going to go back a bit more.
But they'll all have my contact information on the email I sent to them anyway.
Right. Great. So thanks, everyone. Kay, thank you for your contribution.
Thank you, Ian.
And for inviting me along. And everyone have a lovely day and stay safe. Thanks, everyone. Bye-bye.
Bye,
Thanks,
everyone.
Kay. Take care. Bye-bye.